Hi, my name is Jamal Jackson, and I'm the CEO and Managing Attorney of Jackson Corporate Law Offices. This is the second of a three-part series discussing corporate branding and trademarks. Now, as a reminder, these are the objectives that we are trying to achieve over the course of these three sessions. Now, in the first part, we went over understanding what a trademark is, learning how to search for a trademark, and then identifying the different levels of trademark protection. In this session, what we will discuss is the actual trademark registration process, and we'll talk about some of the information that you need to gather in order to fully go through that application process. So, registering your mark. And this is going to really focus on the federal and international registrations. So this is the general process guideline of what you have to do in order to register a mark. So select the mark, gather information and documents, file the federal application, and then if you would like, file the international application to receive protection in countries abroad. So selecting your mark, the first thing that you have to do is you have to identify what type of mark you have, and based on that identification, you'll know the strength of your mark. Now, as a practical matter, outside of understanding what this scale means, it's very, very important to choose a mark that no one is really using in the marketplace, choosing something that is extremely unique, because remember, your branding is a method and a means of differentiating your products and services from that of your competitors. So here you have the scale that the USPTO uses in order to identify the strength of a trademark. So at the top you have fanciful, and we'll go through these in detail and identify what each of these terms mean. But at the top you have fanciful, then you have arbitrary, suggestive, and descriptive. And so going from the top down, they go from stronger to weaker. So at the top, we have fanciful marks. Now, these are marks that are completely made up. They had the words did not exist before the individual or company created them for the sole purpose of being a trademark. Now, these receive the broadest scope of protection. And the good thing about these marks is that you can't take a fanciful mark from a company and then use it in connection with a different good or service. So an example of some fanciful marks: Verizon, Pepsi, and Kodak. So those are all terms that did not exist in the English language before they were created as a trademark for the purposes of these companies. Now, next down, you have arbitrary marks. Now, arbitrary marks, these are terms that already exist in common language, but they're used in a fashion that is different than their dictionary definition. So again, Apple for computers rather than Apple, Jaguar for cars rather than animals, and Google. So these are words that have had their meanings morphed in order to fit a good or service of the company that is utilizing them. Now, this is the second strongest type of trademark. Unlike a fanciful mark, if you have an arbitrary mark, you can't stop someone else from using that mark in connection with the goods that the goods or service that the definition of the word actually identifies. So Apple, the technology company, can't stop an actual Apple farm or Apple production company that's actually in the fruit business of producing apples. So arbitrary marks and fanciful marks are the top two types of marks, and they receive the greatest amount of strength from a legal standpoint. Now, next down, you have suggestive marks. Now, suggestive marks are terms that imply a benefit or attribute of the goods or services for which they are used. So, Airbus for an airplane, the Home Depot for goods that are utilized in the home, and then Volkswagen for a car. So these don't flat out tell you what they are, what the services are, what the goods are, but they imply a benefit or attribute of the good. Now, these are sometimes confused with the next one that we'll talk about, which is descriptive marks, and they receive lesser protection than fanciful and arbitrary marks, but they still receive a good level of protection. Now, descriptive marks, these are terms that actually describe a characteristic or aspect of the good or service. So, World Book for a dictionary, Best Buy for purchasing goods and products, and then chapstick for chapstick. Now, these terms receive very little protection, and the reason that they receive very little protection is because they are they're too close to describing the actual product. And as the term indicates, they are too descriptive. Now, it's very difficult to actually federally register, federally trademark a descriptive term, but it has been done. So of the four that we've discussed, if you're going to trademark, it is highly advisable that you try to stick with a fanciful or arbitrary term because those receive the broadest amounts of protection. Suggestive marks receive an adequate level of protection, but still a lesser amount. And then descriptive marks receive very little protection, and they're hard to actually push through the registration process. Now, surnames. There are a lot of individuals who create businesses or products where they want to incorporate their last name into that product or service. Now, these are generally based in the same category as descriptive marks, and you cannot register any trademark you cannot register the trademark of a surname unless it has achieved a secondary meaning. So, like McDonald's and Hyatt. McDonald's was only able to receive federal registration because it became the behemoth of a company that it did today. And the same thing with the Hyatt, because whenever you say McDonald's, people automatically think of burgers and fries. Now, what you can do is if you have a name that where a part of it is the surname, but it has other titles in it. So if I wanted to trademark Jackson Boxing Company. I can trademark the logo and the name, but what I can't do is carve out exclusive use of the name Jackson for goods or services that include or are related to boxing. And then you have generic names. Now, generic names are the weakest of all, and you cannot trademark a generic name. So this is something like shredded wheat. And so if you have a product or service and you're really trying to receive protection, stay away from generic names. So after you have identified the strength of your trademark, and if you have a trademark that can that's actually eligible to receive federal trademark protection, the next thing that you want to do is gather up your ownership info. Now, a trademark is an asset that can either be owned by an individual or a business. So meaning you can either file the application in the individual's name or the business's name. So that's the first thing you have to decide. You have to go back and think about your first date in use, and that's the first date in use in commerce. So when was the first time you sold the product, you started marketing the product, you actually put it out for consumers to be able to purchase or utilize that good or service. The next thing you have to do is gather the drawing, and the drawing is just the logo design. You can get a computer PDF rendering of the design in order to submit with the trademark. That's if it is a logo. If you're just trademarking a name and it's just a basic word mark, you don't have to worry about getting a drawing. And then the next thing that you have to do is not locate, but you have to submit a specimen with your application. Now, a specimen is your proof of using the trademark in commerce, and so it shows the exact way that consumers engage and interact with that product or service in commerce along with that trademark. And so acceptable specimens for a registration are for goods, so tags. So if you're producing t-shirts, having the logo on a tag, and not necessarily the tag that's sewn into the shirt, but maybe a price tag that's added to the shirt, or some other tag that is put on the shirt. Package and labeling, and then in certain cases you can use a website. And then for services, advertising material, brochures, websites, business cards. Now, there are some cases where you'll submit one of these with your trademark application, and the USPTO will come back and say that they need a different specimen for whatever reason they feel the actual specimen is not adequate for purposes of saying that it's identifying the source of goods. Now, one issue that a lot of people run into is when they create t-shirts, they try to submit a specimen where they have a design that is very large across the front of the shirt. The USPTO will not accept this because they see that as being more decorative than as identifying a source of goods. So that so when you think about a specimen, think about this, and there are searches that you can do on Google in order to figure out what an acceptable specimen is for your product or service. Now, the filing fees are as such. So it costs $225 or $275, and everything is done electronically. You log onto the USPTO website, and there's a link in order to submit the application. Now, the difference between the 225 and the 275 mark is this. In the application, there are set labels and set descriptions that the USPTO has. So if you can fit your product or service under these set labels and set descriptions, then you receive the lesser cost of the 225. If you have to write out your own description of the goods or services, then that's 275. So I'm sorry, 225 if you can use their descriptions. If you have to write out your own description of the goods or services, then it's 275 per class. And so classes, that is something that individuals sometimes have a hard time grasping. And so the class is just the industry or the type of good or service that you are putting into the marketplace. So there are 45 total classes, and the USPTO goes off of international classes. And so what we're going to do is we're going to figure out how do you search for the class that your good or service is in. So again, pull up the USPTO website, www.uspto.gov, and up here you see that there's a quick link, and this is going to show you how to search specifically for the product or service that you're putting out. So you go to quick links, and down here you see ID manual, and so you click on the ID manual and it brings you to this page. Now on this page you enter your search term, and so here I'm not sure if you can see it, I entered legal. Just so that we can again use our law firm as an example of if we wanted to go through and trademark our logo and name. So I put in legal, and then it takes me to this, and so it gives you different hits and shows you the classes that these hits are in. So down here you see that we would be in class 45, and that covers attorney services, namely representation of clients, and then it'll have you fill in the type, well, it would have us fill in the type of legal services that we actually provide to our clients. Now, going back, if you want to browse through all 45 classes, then you can go to the USPTO website. In the top search term, or in the top search box on the top right-hand side, you would enter class search, and then it'll take you to this page, and go down here, and it gives you the and if you click on the Nice Agreement 10th edition, it gives you general remarks by class. So click on that, and it'll take you to this page. And from this page, it gives you a definition of goods and a definition of services. And then you can scroll down. They have all 45 classes on there, and they have explanatory notes. So if we scroll down to class 45, it shows that class 45 covers legal services, security services for the protection of property and individuals, personal and social services rendered by others to meet the needs of individuals. And then it has the different examples of what the class includes. And then there are some categories that have specific examples of what the class does not include. And then there are some that have additional explanatory notes. So that's an easy way to go in and just peruse through the 45 classes and see, kind of get an idea of if your good or service will be classified into one class or into 3 classes. Now, the the timeline for this is 6 to 8 months on average. After you submit your application, it takes about 3 months before that application is even assigned to an agent, to a USPTO trademark agent. And what that agent does is they go through the application and they have follow-up. So they'll tell you if anything needs to be changed in the description, if they see any issues with the application. And so you probably have a few back and forths in order to get the application to where they feel it's adequate enough to push through. Now, once the agent has approved the application, it's assigned, or it's published for opposition in the official gazette. And what this does is this is the time period where it puts everybody on notice that you are filing this trademark. So if anyone has an issue with the trademark, anyone feels like it infringes on their trademark during this 30-day period, that's when those individuals are able to come forward and voice their opinion and submit an opposition to your application. Now, if anyone does submit an opposition, then you have to go through the process of trying to refute that claim. And then, but if no one approves within the 30 days, then your application is approved and you'll receive an official certificate roughly 11 weeks later. Now, for the international system, again, it goes through the WIPO organization, the World Intellectual Property Organization. You have to have your trademark registered or pending in at least one of the countries that are a part of the WIPO organization's site. So what's called, as we went over in part one, the Madrid Protocol. Now, if you are trying to file a U.S. trademark based on an international application, then it's $100 per class. If you're basing it on a single trademark, $150 per application if it's based on multiple trademarks. And so we just went through and we did kind of an example. And again, on the WIPO website, there's a calculator where you can go in and you can choose where your mark is registered and where and in what countries you're trying to register it, and it will give you a calculation of how much you are going to have to pay. So we said one mark in one class in 3 different countries, and because of where the WIPO organization is centered, it gives you the price in Swiss francs, but then you can also convert it. So the conversion is roughly a little under $1,600 for the calculation that we did. And so the timeline for an international trademark is a little bit long, well, a lot longer than a trademark that is domestically filed through the United States Patent and Trademark Office, and that's typically 18 months or more. So this slide just shows some of the common reasons that trademarks are denied registration. So similarity of the marks. So whether it's the sound, or whether it's the appearance, or whether it's the meaning. Now, understand that for languages that are commonly spoken in the United States, they're going to take into account if your mark is just the same word in a different language. And there are some applications that will be denied if that is the case. For sound, you see we have C stars and C stars. Sound is one of the important aspects of pushing a trademark through. The USPTO is very adamant about not creating confusion in the marketplace. So even if your trademark sounds the same as a different trademark but is spelled differently, that could be grounds for having your application denied. And then you have relatedness of goods. So shirts versus pants, both clothing, they're not that far apart from each other. Shirts and pants manufacturer versus online clothing retailer, and then banking services versus mortgage lending services. So these are things that you all want to be cognizant of when you are actually branding yourself, figuring out what trademark you want to officially utilize to identify your goods or services, and really understand that these are some of the points that you want to avoid so that it's easier to push your application through. Now, again, my name is Jamal Jackson, and this was part 2 of the 3-part series over corporate branding and trademarks. And again, if you have any questions over the material that was covered, please feel free to reach out. All of my contact information is on this page. If you would like a follow-up discussion, again, reach out. I always advise individuals, business owners who are serious about protecting their brand to have a conversation with an attorney, to really speak to an attorney about what they need to do. The information that is being given to you is a good starting point, but you always want to consult a professional in order to make sure that what you're doing is going to give you the type of protection that you are really looking for, so that your trademark, your intellectual property is not jeopardized as you use it in connection with your goods or services. Now, in the final installment, in the 3rd part, we're going to talk about how do you maintain your protection after you've actually finished the trademark application and you've been granted a federal trademark. So that session is coming up shortly, and I hope that you all will tune in. And again, I hope that you all receive some good information here. My name is Jamal Jackson, and I look forward to talking with you again soon. Thank you.